All right, we're joined on the panel now by Judge Berger. We welcome her. We now have the case. Let's get the papers out. Of the Floyds versus the STOUMBOSes. And we have a cross appeal, so the cross appellant can reserve some of their time for cross rebuttal if they choose to.
Good morning, Your Honors, and may it please the Court. My name is Kevin Robinson, and I represent the appellants, the cross appellees, Mick and LINDAFLOYD. Mr. and Mrs. Floyd are in the gallery with me today. I would like to, with the Court's permission, reserve 5 minutes of my time for rebuttal. Your Honor, this matter arises out of a dispute between neighbors. There was originally a 6-count complaint filed. 3 counts were dismissed prior to trial. 3 counts were tried in April of 2014. Those counts were a breach of a written contract count, a breach of an oral contract count, and a fraud count. Of the 3 claims that were tried, the trial court ruled in favor of the Floyds on 2, the breach of the oral contract count and the fraud count. On the breach for the written contract count, the trial court issued a split decision. The breach of the written contract count was in essence a claim that a dock was not constructed according to plans that the parties had agreed upon. The trial court found that some aspects of the dock or some aspects of the complaint were unfounded and that the dock adequately was constructed with respect to those conditions. But in one material respect, the court ruled against my clients. On that claim, the court ruled that the plans that were agreed upon by the parties contained an ambiguity, and that ambiguity resulted in a confusion about what the total square footage of the dock would be.
Do you agree, though, that if there is an ambiguity, it's to be construed against the party who drafted the agreement?
Your Honor, that is one commonly accepted rule of construction, and I don't disagree that case law across Florida and frankly nationwide holds that. In this particular case, Judge, I think there are 2 important issues to look at, to examine. The first is, I don't believe it was appropriate for the trial court to rule that the appellants were the sole drafter of this contract, these documents, and I think the record supports that. Moreover, when we look at rules of construction, Your Honors well know there are a multitude of rules of construction. They're often competing. In this case, I think the appropriate rule of construction to apply to this particular contract is that the rule that says that where there are specific provisions of a contract and general provisions of a contract, the specific provisions should apply. That's particularly important in the context of this case, and the reason is we're looking at plans, drawings, architectural drawings for the construction of a dock. Now, there's absolutely no dispute in the record evidence that the dock that was constructed on the Floyd property is consistent in every material respect with the plans as drawn. What I mean by that is if the plans say that one span of the dock was 18 feet and 5 inches, all of the record evidence confirms that as built it was 18 feet 5 inches. If the other span was 4 feet 2 inches, that's how it was constructed.
But the plan was more square footage than the contract or the agreement actually set for.
Your Honor, the 2 competing provisions are the plan. They're on the same document, the competing provisions. The first competing provision is if you multiply the dimensions, the specific dimensions on the dock, it adds up to 2,343 square feet. On the other hand, there's a term, a phrase on the plans themselves. It says total proposed covered dock size, 2,089 square feet. There's about a 250 square foot difference. So absolutely, if you're going to interpret the phrase total proposed covered dock size, 2,089 square feet, to mean that's the total square footage, it's inconsistent with the actual square footage when you apply the dimensions.
Does that create an ambiguity, though? Which one are we supposed to look at? Are we supposed to look at 2,089, or are we supposed to look at 2,300 and something?
Your Honor, I think I would say 2 things. The first is, to the extent that we're going to characterize this as an ambiguity, I think it's actually a repugnancy, and I think there's a little difference there. An ambiguity means you can interpret something one of 2 ways. A repugnancy, on the other hand, means you have 2 provisions that are irreconcilable. That's what we have here. If the Floyds had constructed a dock with a total square footage of 2,089 square feet, using the trial court's interpretation of this document, they would have necessarily breached the contract, right? They were in a no-win situation. Any dock they constructed was going to be a breach. If it was 2,089 square feet, that necessarily means that the dimensions and the configuration of the dock that they constructed didn't match what was on the plans.
But let's assume that these two provisions are inconsistent, and they seem to be. I mean, there's no question that on one says 2,089 and the other one's about 2,400. So there's an inconsistency, repugnancy. So the court considers parole evidence. And tell me what, you know, in one line basically, what the position of the Floyds was and what the position of the Stoumboses was on that narrow issue. And apparently the trial court concluded that it concluded that the agreement was for the smaller number, the 2,089. So tell me,
Correct.
Crystallize for me what their respective positions were in their testimony and why the trial judge wasn't within her discretion to accept whatever she accepted.
The position of the Floyds is they thought they were agreeing to construct a dock that was consistent with the dimensions shown on the plans. The position of the Stoumboses was they thought they were agreeing to the construction of a dock of 2,089 total square feet. The reason that it was improper for the trial court to issue the ruling that she did is twofold. One, I think the record evidence shows that the Stoumboses' stated position that they didn't know the dock was going to be larger than 2,089 square feet, it doesn't square with the actual testimony. But moreover, I think if we look at the case law here, it's improper if there's a discrepancy like this for the trial court to say, well, I'm going to go with the Stoumboses on this one and not the Floyds. And the reason is, if the Floyds thought they were agreeing to the construction of a dock that's consistent with these dimensions, that's what they thought they were agreeing to. Let's assume, for purposes of argument, that the Stoumboses thought they were agreeing to a dock of a total of 2,089 square feet. Total square feet. That's great. That's what the parties thought. As Your Honor noted, those things are inconsistent. So the appropriate remedy here, where there's no meeting of the minds, if we accept each party's testimony that there's no meeting of the minds, the appropriate remedy here is rescission, because there's no agreement. The parties never agreed on anything.
Where does that leave you? Tear the whole thing down and go back to 999 square feet?
I don't believe that that's the necessary result. It's possibly the result, but I don't believe it's the necessary result. This takes us kind of back to the beginning of the story, and I'll get to why I don't think that's the necessary result. The Floyds sought the Stoumboses' consent to this variance because there are essentially two ways to get a variance. The first and easiest way is if adjacent property owners will agree to a variance, the Orange County Environmental Protection Division, EPD, which is the governmental entity that has jurisdiction over this, the EPD will usually grant a variance if the adjacent property owners don't object. That's not the only way that you can get a variance. In fact, the appellant's answer brief acknowledges that if this agreement had not been reached on April 19th, 2013, the Floyds were going to commence proceedings in Orange County EPD the following day, April 20th. That was the deadline for them to commence their proceedings. We don't know if EPD would have granted a variance or not. However, the Floyds didn't build the dock on their property because the Stoumboses agreed they could. The Floyds built the dock on their property because the EPD said they could. The EPD permitted it, okay?
But they permitted it because you had your neighbor that consented to it.
Absolutely.
That factor. I mean, you don't know for
Absolutely.
sure that we can only speculate what would have happened had they not consented.
Absolutely. So, in answer to Judge Orfinger's question, if this contract is rescinded, what that means is there's no agreement between the parties, which means that the Stoumboses can contractually, they're well within their rights to withdraw their non-objection to the variance. They can submit that to EPD, and they can argue to EPD, hey, EPD, you permitted this solely because we agreed to it, and they can ask EPD to withdraw the permit. We don't know what EPD will do. Maybe they will, maybe they won't. But the fact of the matter is, EPD is not a party to this lawsuit. The court doesn't have jurisdiction over EPD. We can't force them to do anything. So, Your Honor, that may be a result. It may not be. I don't think we can answer that question. Your Honor, with respect to the written agreement itself, the ambiguity is an important issue. There's another important issue as to why it's not enforceable against appellant LINDAFLOYD. All of the record evidence is that LINDAFLOYD was not a party to this agreement. So LINDAFLOYD is a co-owner of the real property in a tenancy by the entireties. Florida law is clear that when you own property in a tenancy by the entireties, you own an undivided 1/2 interest in the property.
But didn't the trial court find that Mr. Floyd was authorized to act as her agent?
That was the basis for the trial court's conclusion that LINDAFLOYD is bound by the written agreement.
Argument that there's no competent evidence to support that.
It is, Your Honor. Respectfully, we believe that the trial court misapplied the evidence that was before the court. If we look at all of the testimony, the appellees themselves admitted that, well, let's look at their complaint. Defendant MICK Floyd entered into the written contract, not LINDAFLOYD, the complaint at paragraph 16, 18, 19, and 37. The allegations of their complaint are fully consistent with the written agreement itself. The written agreement is written in the form of a letter from MICK Floyd to Mr. STOUMBOS. It uses singulars.
When they applied for the EPD permit,
Yes.
was that done by Mr. Floyd, Mrs. Floyd, or both Floyds?
That is an incredibly pertinent question because it goes to some of the evidence that the appellees cite in their answer brief. Now, there were prior applications to the EPD going back to 2011. Some of those prior applications do, in fact, they were filed by MICK and LINDAFLOYD, but this particular application, it's in the record evidence before Your Honors, was filed only by MICK Floyd. And if we look at all of the subsequent EPD correspondence and proceedings on this issue, and there were many, all of those are issued to MICK Floyd. They talk about the MICK Floyd variance.
I mean, if we take that to its logical conclusion, though, doesn't it mean that the permit wasn't even properly issued? If the proper applicant, I mean, it seems to me that you can't have it both ways. You can't have a permit issued to only one of the two owners and want to keep the benefits of the permit, but on the other hand, on the STOUMBOS, we'll call it the agreement, whatever it is, you know, you want to reject that because it's only signed by one of them. I mean, it seems like you want to have the best of both worlds on that.
Your Honor, I believe what the case law says on this is that to bind a spouse through this implied agency theory, you have to have, one, clear and convincing evidence, and two, you have to show actual knowledge and active acceptance of the benefit. Here, what all of the record evidence shows that to the extent that Mrs. Floyd was benefited by this at all, it's all passive. The limited record evidence that relates to Mrs. Floyd's involvement in this is that there were occasions when she sat on the dock, there were occasions when she launched a boat from the dock, and there were occasions when she saw dock construction. Now, let's be clear. None of that record evidence says that Mrs. Floyd was a party to this agreement, allowed her husband to enter into this agreement on her behalf. In fact, none of that evidence even suggests that Mrs. Floyd knew a variance was required to build this dock. There is, however, Your Honors.
Presumably, if she had signed, well, I guess she signed permit applications, not necessarily variance applications. I don't know what she signed.
Your Honor, I don't believe that she signed the permit application on this. I believe MICK Floyd signed the permit application on this, for this particular variance. Again, I want to be clear, she was a party to 2011 applications with EPD, but those were for different plans, different docks, distinguishable.
Wasn't there some testimony, though, that, and correct me if I'm wrong, and I don't have it right in front of me, but that she made some statements to the effect of, you know, she was under a lot of stress, she didn't want to deal with the neighbors, and so she sort of left that to her husband to deal with because she just didn't want the stress of it?
Absolutely, Your Honor. So,
That's some testimony that the court could have considered?
I believe the court...
The agency?
I believe the court should have considered that, but I believe it leads to the opposite conclusion of what Your Honor suggests. So what Mrs. Floyd said is that she'd had a heart attack some months prior to this, popping up. And what she said is, I didn't want to deal with this at all. I was hands off. This property, whatever Mick wanted to do, I would let him do. That, Your Honor, though, let's be clear, that is passive. Whatever he wants to do, he can go and do. He doesn't have to tell me. I don't care. So she doesn't know what's going on.
Let me ask you
That doesn't imply, though, if he wants a 2,089 square foot dock or a 2,400 square foot dock, she's okay with it.
She's okay with it passively, she's okay with it in as much as she's not actively
You're in
objecting
for
to
5
it.
minutes if you want to hold on to it.
I would like to reserve, Your Honor. Thank you.
Thank you. How much time would you like to reserve?
3 minutes, please, Your Honor. And good morning, Your Honors. My name is Derek Angel with the firm of O'Connor & O'Connor. We represent the STOUMBOSes. And on the primary appeal, we heard about the ambiguity question. It's really a two-step process. The first is a matter of law, whether there's ambiguity. I think the court is correct, there is. I think Mr. STOUMBOS, who's not trained in construction drawings, is entitled to rely on, in the very center of this document, large typeface, which I think the best quality representation we have in the records at 946 says total covered dock size of 2,089 square feet. Well, what does that term mean? And I remember learning in law school, the parole evidence rule really is the most appropriate when you're dealing with technical industry terms. And here, that term was subject to different interpretations. It remains to be subject to different interpretations on appeal. And our expert, Mr. Kelly, testified that that term is synonymous with, in the dock industry, I suppose, of terminal platform square feet. That term was used throughout this entire case and really means just that portion of the dock after you go to the walkway, the end of the dock, the first level, does not include the top level. And as Judge Doherty found, that number, that 2,089 square feet, was a material term that went to the essence of the contract because originally it was 2,000 square feet. It was double the size of the dock that Mr. STOUMBOS acquiesced to in exchange for this setback that I'll talk about in a moment. And then there were some changes, and Mr. Floyd said, well, I've got a little bit more, and Mr. STOUMBOS said, that's it, Mick, we're at 2,100, we're done. And so when they look at these plans together, and they see these, and now with the help, the aid of engineers to find out that if we use the geometry and the math, we see there's actually somewhere around 2,350, now we see that that gigantic 2,089 foot representation does not comport. And so once we determine as a matter of law there is ambiguity, it becomes a factual question to resolve it. And as long as we know, as long as there's competent evidence to support the trial court's finding, it must be affirmed. And certainly an engineer, Mr. Kelly, saying that it is synonymous with terminal platform square feet, we have that finding, and I believe it's appropriately affirmed. But not just Mr. Kelly, right? The entire Orange County officials, they all were under the presumption that this was a terminal platform number. That's how they issued their fee, if you will, for when you cover up some of the native waterbed, they have environmental concerns or whatnot. And let's not forget that the original dock, the 999, that number said total covered and also was synonymous with terminal platform. So I think what probably happened is there's some evidence that there were some changes in these plans that happened overnight. It's possible that the architect simply forgot to update that number, but in any event, we are left with a ambiguous document, and I think that Judge Doherty properly applied the law and reached the conclusion that she did as to that ambiguity. As far as the agency question between the Floyds, this is a factual question, right? The case law is replete with cases where if agency is not absolutely established through an employment or whatnot, or absolutely not established, there's almost always factual questions, and I can't imagine a better example of a fact-intensive case than this one. And Judge Doherty, in several places in her amended final judgment, spoke about the significance of the credibility of all of these witnesses. It's several times she brings it up, the importance of course, observing the candor of the demeanor, and in several places she basically ratified Mr. STOUMBOS' credibility and never once commented on the Floyd's credibility. I think reading between the lines, it's pretty clear which side of the coin she fell on that. And what we learned from that, especially on the appellate level, is where a witness answers a question no, where there's credibility issues, the finder of fact is entitled to infer that the real answer is yes. And when I read through the briefs again, they rely heavily on Ms. Floyd's own testimony in denying any sort of agency with respect to the dock. I think Judge Doherty was within her rights to assume that those were not entirely true answers. And on top of that, as the bench noted when Mr. Robinson was here, all of those other inferences, the conduct of the parties, that's how you can develop an agency. The conduct, that she said, that made no odds to me what Mr. Floyd does with the dock. She knew her name was going to be on all these documents. She didn't care. She knew that he was going to be out there with contractors working on this dock, with her name being bandied about. It didn't matter to her. That, to me, is an agency. You know, not to mention that we're only looking for competent evidence. I think we certainly have that. Also, this rescission issue, which frankly I'm surprised that they're maintaining, because as Judge Orfinger, you noted, rescission, if that's ordered, we return to the status quo, which is the 999 square foot dock. And as far as what EPD might have done, that's not an issue here, because the parties stipulated. The pretrial stipulation states, I was looking for the record citation, I don't have it unfortunately at my fingertips, but it's in our briefs, but the stipulation was that Mr. Stoumbos's his consent to this dock was required for EPD to allow them to build this gigantic dock. And so that's not an issue on appeal. That was agreed by the parties pre-trial, that without Mr. Stoumbos's consent, we don't have this dock. And so if we are talking about rescission, then I think, yes, we have to go back and tear down the entire dock. There's a court of equity below. Judge Doherty could have ordered that. In fact, I think that frankly would have been an appropriate remedy had she decided to go that route, being a court of equity and the broad discretion that Her Honor enjoyed. Of course, she chose to order them to remove 300 square feet of dock. That's one way to do it, and I don't think there's anything wrong with that order. It's within her discretion. It doesn't leave them confused, as they claim in their brief, because it doesn't say that the 300 feet that are removed must comply with the plan. It says, remove 300 square feet, that's my order, we're done. That's basically what it says. And the mooring posts, which he does say must comport with the plans, because they have 3 additional mooring posts, which were a material part of this whole discussion, because those mooring posts go right up against this property line, and the boats, they float around, and the Stoumboses have that ramp there with the dog and the kids. So these were material elements of the contract that were breached, and those findings, I think, are fully supported by the evidence. And so if there's any questions about the primary appeal, I'd like to move to the cross appeal, which of course deals with the statute of frauds.
Well, let me ask you just one. Both sides here have motions for attorney fees pending. Obviously, it depends on how we resolve this case. You agree, though, that whatever side prevails on the written agreement would be entitled to fees, but not as to the issue of the oral agreement, right?
I agree. I think
okay, part 2. There's no second appeal regarding an attorney fee award below. Was there an attorney fee award entered?
Well, that's outside the record because it occurred post-judgment, but since the court asked, yes, the fee has been liquidated. They did not appeal the fee order. They posted a bond on the fee order. That's a separate judgment. We also...
Your fees as to the written agreement?
Yes, Your Honor.
That was what was ordered below?
Yes.
Okay. Right.
So that's been concluded. That judgment has not been appealed. We also have, I believe, a pending motion for attorney's fees in this court for appellate fees based on the same agreement.
Let me ask you on your cross appeal, before you go into the statute of frauds, let's talk about the agency aspect of that. You've outlined, I think, a reasonable argument on the agency on the primary appeal. But one of the findings of Judge Doherty on the cross appeal was that Mrs. Floyd did not give Mr. Floyd the authorization to agree to different setback, the 40-foot setback. So why doesn't the very argument that you made, I think convincingly on the first part of the appeal, come back and bite you on the second part?
Because, and thank you, Your Honor, but it's a different question. The question is only whether or not, and I respect that Your Honor made an agency finding against us on that one. I've not challenged that because of the factual nature of agency inquiries. But the question before the court was not whether this was enforceable against Mrs. Floyd. It's not even whether it was breached at this point. Its sole question, because of the way the final judgment was written, is whether or not the statute of frauds renders the oral agreement unenforceable against Mr. Floyd. Now, from a practical standpoint, if we go down the line and they build this house there, whether Mr. Floyd, Mrs. Floyd are liable on whatever it may be on the oral agreement, that's for a later day. The only question
You
to...
made no claim for damages under that count. You're just asking for injunctive relief. So you're asking us, if I understand the reply, the end of your reply brief, you're saying, send it back, because statute of frauds does not apply, send it back, trial judge determine whether there's been a breach of the oral agreement by Mr. Floyd, and if so, fashion an equitable remedy. And I'm at a loss, having been a trial judge for 14 plus years, if the DCA sent that back to me and say, okay, this agreement's not binding against Mrs. Floyd. The agreement says you can't build within that 30-foot space here. Figure it out, trial judge, what you're going to do. I mean, I would see Mrs. Floyd could say, well, I had nothing to do with that. I want to be able to build my house where it's legally permissible within 10 feet of the setback line, and that's what I want to do. You know, that's... what does a trial judge do in that?
There are two aspects to this, to the answer to your question, Your Honor. First of all, it's a court of equity. Broad discretion. Who knows what one judge will do versus another judge? And some judges might say enforcing this at all is inequitable because of what you're mentioning. But there's another far more important aspect to this, which is that the trial court has now ruled that this oral agreement is entirely unenforceable under the statute of frauds. That means that, let's say, totally hypothetically, but this is why this is significant, and I'm not suggesting this is in the near future, but what if the Floyds are to get divorced and Mr. Floyd retains sole possession of the house? Well, then clearly it'd be enforceable against him. But if Mrs. Floyd retains the house, it would not be enforceable at all. As we have it today, we have what I believe would be res judicata as to any future argument that it's not enforceable against Mr. Floyd, given the way the court resolved it. So it becomes a question of practicalities. Yes.
All right, I'm still the circuit judge. You say, okay, your argument back on remand is, well, judge, enter an injunction against Mr. Floyd because maybe they get divorced and he ends up with the house.
Or what have you. There could be all sorts of different things. The house has been transferred to a different entity as it stands. But the question was solely on the first instance.
He transferred the house to her. Then I guess that's the end of it.
It may be, though I think that, again, this has to be looked at really in the first instance by the trial court, because it never reached this point because it stopped at the statute of frauds.
But you're saying to me as the trial judge, I'm putting my trial judge hat on, you're saying to me it can go back and I can consider as part of the equitable resolution on remand that I don't want to have an injunction entered against to enforce this 30-foot setback requirement because Mrs. Floyd actually didn't agree with it, and I didn't find that she agreed with it, and that got affirmed on appeal.
I think that would be one judge might do that, right? We would be unhappy with that, of course, but that's...
Sure, yeah, you'd be happy to win and you'd be unhappy to lose.
But my point is, another judge might say that as long as Mr. Floyd is actively involved in the construction, the control of the house, and the location of the house on this lot with 200 feet of waterfront, that he is not entitled to locate the house where it is.
Let me ask you this. I mean, it sort of gets into the, I mean, if it binds, if it is solely to Mr. Floyd, but then he wanted to transfer it, and you argue that it would bind Mrs. Floyd or anybody else you would want to assign it to, doesn't that bring it within the statute of frauds?
Well, and I think the only evidence of that is the extent of the scope of this oral promise is found in the written agreement, which has that language, which limited. This goes back to my argument in the brief. My first point about the personal covenant issue is that, and this is unusual for these sorts of contracts, it says, so long as I own, control, or participate in the use of the reference property. It doesn't have that language that we put in just about every settlement agreement I've ever seen, you know, heirs and assigned, successors, transferees. This is very limited to the immediate parties to this agreement. And that's the only evidence we have about the temporal length of any of these agreements.
But are you arguing that that part of this agreement was in writing and part of it's oral?
The way I look at this is that this is a global agreement. It's no different than buying a house. When you close on the loan, you sign about 70 different pieces of paper. You don't have separate consideration for every one of them. You know, the consideration here is obvious. Mr. Stoumbos is withdrawing his consent or his objection, and in exchange, Mr. Floyd is building his house 40 feet back. And I know they try to cast these as two entirely independent contracts. That is just clearly not at all what happened here. Mr. Stoumbos had zero incentive to acquiesce to the dock placement without that 40-foot
The
setback.
problem is that you don't have anything in writing with regard to the 40-foot setback. And I understand that there's some suggestion that there was a reason why,
There's
in
lots of
terms of
reasons
not
why.
mucking up the situation with the environmental department. But there's nothing in writing, there's nothing, no evidence other than parole evidence that was an agreement.
Well, I don't think parole evidence is what we're looking at here. Parole evidence is used to define uncertain terms and ambiguous terms in a contract. This is part and parcel of one larger agreement, but they were two distinct agreements in the sense that they're the same global agreement in the sense the same consideration supports both of them. It's the same global transaction, but they were two separate agreements, if you want to look at it very technically, which is what we're doing here. And so, without having it written down, that makes a problem for proof, but not for enforceability if the court agrees with me that this is outside the statute of frauds. And Mr. Stoumbos proved, by preponderance, that the agreement existed. The trial court found that the agreement existed, and she found what the terms of the agreement were. As findings of fact, the amended final judgment says we agreed to set it back 40 feet.
But if there's no agency, then Mrs. Stoumbos can build the house. I mean, how is it, it goes back to what Judge Lambert asked. I mean, how is it enforceable? How is it an enforceable contract if it's just against one party and not the other? And if it isn't enforceable against her, then she could just build the house. If it is enforceable against her, then how does it not within the statute of frauds?
Well, I think that, again, this goes to questions of what will happen in the future. How will they build their house? Where will they locate it? And who will be in control of what? I think that's what it comes down to. And then if it's proven that Mr. Floyd is actively involved in the design, the construction, the location of the home, an action could be brought, or post-judgment proceedings or what have you, and at least be entitled, even if the trial
I guess my
judge...
question is this a personal covenant, or is this a covenant that runs with the land?
Well-
Is this a restrictive covenant?
Well, obviously, I've argued that it's a personal covenant because it does not run with the land, because of the evidence that we have in the written agreement that they were intending to limit it to the immediate parties and perhaps a transfer trust or something where they're still in control. But like I said, it lacks that language, successors, assigns, transferees, that sort of thing. And this was, at this point, let's not forget, they had lawyered up. And that's another reason why Mr. Floyd begged as the language in the record, begged him not to write this down, is because you got the EPD, you had what looks like a jurisdictional timeline, 30 days to file an appeal on the variance issue. You've got lawyers on both sides, so if you can't just change a line, there's going to be red lines back and forth, and
Let me make sure I understood one of your last comments. So apparently the Floyds are sitting here and they're listing all this, and they can say, okay, not for nothing, if we decide to build the 18,000 square foot house, Mrs. Floyd's going to sign the contract to build the house with the builder, and Mrs. Floyd's going to be involved in that, and then she can absolutely build up to 10 feet away from the setback per the codes.
Well, I think we need to have a court of equity look at, and we're talking about some things that haven't happened yet, to look at it on the first instance. And the only question here is whether or not this is enforceable against Mr. Floyd. That's the only question. And going back through my briefs, and I'm about to sit down here and reserve my time, but frankly, I should have led my cross appeal with my second point, which was that this is an equitable remedy, and it's an equitable remedy where our party has performed. And the case law, I think, is very clear. Statute of frauds doesn't apply to equitable remedies where there's performance. And the cases they cited really only reinforce that. The Eclipse Medical case, there's a footnote 6, that case has been cited over 1,000 times for what it's worth. It really lays out Florida's history on that exception, so I don't see how this oral agreement is under the statute of frauds. And again, if we find that it is, and it's unenforceable, that has res judicata effects for all sorts of potential future conduct that we're not here to talk about today, but that's why I think it's important to reverse that particular finding and let the trial judge, as a court of first instance, rule on how, or if at all, to enforce it on other grounds. Thank you, and I'll reserve the remainder of my time.
Your Honors, Mr. Angel said the only question is whether this agreement is enforceable against Mr. Floyd. Of course, that's not the only question. They pled this breach of oral contract claim against both Mr. and Mrs. Floyd, and the court found that it's unenforceable against both of them. The question is it enforceable at all? Judge Berger, Judge Lambert, you raised the points that we believe are pertinent to the answer to that question. Although they try to frame it as a restrictive covenant that's personal to Mr. Floyd, in application, it would be a covenant that binds the land. The case law is clear. Judge Doherty found that Mrs. Floyd was not a party to this oral contract. There is absolutely no evidence that she was, and certainly there's competent evidence to sustain her ruling in that regard.
I think we're confusing two different issues, one of agency and one of whether or not this is within the statute of frauds. And for it to be a statute of frauds issue, it has to create some interest in the land. And my understanding of the law, and I'm looking at a couple of cases out of the second and third DCAs, where they talked about deed restrictions, and where deed restrictions in particular said you can't do X with your land. They said deed restrictions prohibiting a particular use of property convey no interest in the land. And there are two cases that I've got. One's at 79 Southern 3rd 213, and the other one's at 779 Southern 2nd 598. And they basically both say the same thing. So I'm not convinced that if you have an agreement that simply says I won't build within X feet of the property line, that creates an interest in the land. What's your argument that it does?
Your Honor, that's an interesting legal point, and that's the heart of the distinction between the argument I make and the argument Mr. Angel makes. The case law we cited, Gutman v. Vanek, is a 4th DCA case from 2009. That case says that setback requirements are nothing more than a form of negative easement. We cited some other cases. There's a Florida Supreme Court case going all the way back to 1936, the J.C. Vereen case, that defines easements as, among other things, creating a privilege in property whereof the servient owner is obligated to suffer or refrain from doing something on his own tenement for the advantage of the dominant owner. Now, there's a treatise. It's called the Law of Easements and Licenses, and that treatise it provides in part that the distinction between a negative easement and a restrictive covenant. It talks about it, and it notes that when an owner of burdened land is prohibited only from making a particular use of a certain portion of his land, such as building any structure in a specified area, then the interest is probably a negative easement. So if we look at Florida case law, I think Florida case law clearly says that a setback requirement is a form of a negative easement, and some of the literature that examines the issue supports that. Your Honors, I don't know that we even...
I don't disagree with you, but I'm looking at a Supreme Court case from 1955, Board of Public Instruction versus Town of Bay Harbor. And they said negative easements or equitable servitudes are not easements in the strict sense of the word, but are more properly classified as rights arising out of contract. And, I agree with you that they're called negative easements because they prohibit you from doing something, but I think the real question is, does that create an interest in the land? That doesn't have anything to do with the issue of agency. I think those are really two separate issues. So
Sure.
I'm not as sold on your argument that it creates an interest in the land. I'm much more persuaded by your agency argument.
Let me add a third argument. I'm running out of time here, but the last argument that we make is it's the Tipsy Coachman argument. The trial court clearly found that these are two separate agreements. Judge Doherty held that in her amended final judgment, and in fact, that's how it's pled. Count 4, breach of written contract. Count 5, breach of oral contract. Pled as separate contracts, and the trial judge found that they were separate contracts. The Floyds give separate consideration in support for each contract. The STOUMBOSes give one consideration for both contracts, agreement not to object. This agreement, it's insufficient. You can't have the same consideration support a second contract. So this consideration supports the written contract. It's invalid to support this alleged oral agreement, and therefore, for that reason alone, the oral agreement's unenforceable against both parties. I'm out of time, Your Honor.
Thank you, counsel.
Thank you.
mess up the clock, but you've got about a minute.
Okay.
About 2.5 minutes, rather.
Thank you. As far as the same consideration goes, I argue in the brief that you can use, as I said before, same consideration can support multiple contracts as long as they're contemporaneously executed, and I think we have sufficient contemporaneity, if that's a word, in this case, that everything was done together. And of course, this would have been written down if it wasn't for the timing, and Mr. Floyd's begging that we don't write it down to confuse EPD, and also I think the fact that lawyers had already been involved, and
Well, you could have easily had 2 separate pieces of paper that said, we agree to this, we agree to that.
And there's another practical aspect of this. Let's not forget, this was, as the testimony is, this was not supposed to be something that's litigated. This was supposed to be an end to the litigation, end to the lawyers. These are neighbors. Their children had played together. They're on vacations together. This was not supposed to be something that winds up in a DCA, right? So it was.
But all I'm saying is, as a practical matter, I'm not really buying that argument that despite there no doubt was a reason not to confuse the EPD application with the other stuff. It would have been easy to put the agreement about the setback in a separate document.
Well, they had asked for that. That was part of it. In fact, their testimony was there was supposed to be email confirmation that never came. But at that point, we had 1 day to withdraw the.
Well, I mean, but Mr. Stumbos could have just said, well, I'm not signing A unless you sign B. It doesn't take a whole day to sign it.
And you're correct.
Poison.
And obviously, in hindsight, that would have certainly been preferable given where we find ourselves today, but,
Client's a lawyer too, right?
well, he's a criminal lawyer, and I'm pretty sure the last time he heard the statute of frauds was when he took the bar exam in '89 or '90. It was the last time I heard it before I was here. It wasn't quite that long ago. But in any event, I understand. There was a trust, you know, we're neighbors, we're friends. That was part of this whole deal, and as my word is my bond, Judge Dory found Mr. Floyd stressed that, you know, trust me. And so I think there's an equity side to this whole thing, which I'll close with my final point in my brief, that the statute of frauds in this case, I don't think this has ever happened before, where there's been a contract where one party insists that it be not in writing and then uses a statute of frauds to deflect its enforceability. I think that is so inequitable that just cannot be the law, and the statute of frauds, equity, anything else, and at a bare minimum, that very unusual exception could apply to this case. But
All right.
out of time. Thank you very much.
All right, that concludes our docket for the morning. We'll be in recess.